Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. And today we'll continue on what we were talking about yesterday, more about employment law. And I'm very pleased here to have Ryan Edmonds join us again. He came back, I think, about a year ago. So always a pleasure, Ryan, and thanks for joining us here again.
Yeah, thank you. Thank you for having me.
Now, Ryan, perhaps maybe you can give us a little bit about your background. And I know you have some slides prepared as well, and then we can go into Q&A afterwards. So
Yeah,
perhaps we can start with that.
Yeah, sure. So I'm an employment lawyer. My practice is restricted to workplace law, advising both employers and employees. I started off at a large firm called Heenan Blakey. It's a full service national firm with a very strong labor and employment group. And if you want some nighttime reading, you can read about its unfortunate downfall in 2014. I'm sure all the stories are still on the internet. But as they say, a crisis breeds opportunity. So I took the opportunity to set up my own shop, Ryan Edmonds Workplace Counsel, and that's where I've been since. I've written a number of publications on employment and workplace law issues. I've also been an adjunct professor at Osgoode Hall Law School, teaching employment law to upper year students. And I am more than happy to be doing this talk right now. And thank you, JP, for inviting me.
Perfect. So maybe we can get into kind of what you have there, and we can go into some more questions about some related issues. I think you should be able to share your screen, but let me know.
Sure. Yeah. So I've got a brief presentation that just touches on some of the legislative changes that have come about as a result of the COVID-19 pandemic. Some legal considerations as it relates to the Human Rights Code and the common law, some examples from my practice in terms of professional responsibilities gone wrong during the pandemic. It's difficult for me in presenter mode to see chat questions and whatnot. So pardon me if you just bear with me as I go through it. And JP and I were talking about the limitations of virtual formats, and then I'll be happy to answer any questions anyone may have. So with that being said, I'm going to try and not do this wrong. Okay. All right. Am I doing this properly? Yep.
Yep, everything looks good.
Perfect. All right. Okay, so this is me before the pandemic. Just a brief bio, as I've already gone over. Yeah, so we're the biggest legislative change that came about as far as workplace law is concerned due to the COVID-19 pandemic was amendments to the Employment Standards Act, which created something called infectious disease leave. And the purpose of IDL, as it was called, was to give a job-protected leave of absence for employees if one of 6 grounds were triggered relating to a quote-unquote designated infectious disease, one of which is COVID-19. And there was no maximum duration to the leave. The leave lasted for as long as conditions applied. And the idea was to provide protections to employees when, for example, flights were canceled. My assistant's brother was stranded in Peru during the onset of the pandemic for a number of months. Schools closed, people had childcare responsibilities. So these sort of incidental effects of the COVID-19 pandemic, the idea was to balance the interests of employers and employees such that employees wouldn't be punished for things beyond their control. But that wasn't the end of it. That was in March. In April, the unemployment rate almost doubled from the time in March it over doubled actually from February to April, went from 5.5% to 13%, the highest unemployment rate that Canada had seen since June 1993. In April, almost 700,000 jobs were lost in that month alone. And that was coming off March, where about 400,000 jobs were lost. So as you can imagine, is quite the time to be an employment lawyer. But the big thing that was lurking in the background was the employees who were put on unpaid layoff. So very, very briefly, A non-unionized employer does not have the inherent right to put somebody on a temporary unpaid layoff. That's very common in the unionized world because it is an explicit right given to an employer in a collective agreement. But in a non-unionized workplace, an employer does not have an inherent right to put somebody on a temporary layoff. They can do it, and if nobody speaks up about it and nobody protests, or they, even go so far as explicitly agree to the layoff, then that's fine. But otherwise, it's two things. One, it can be a constructive dismissal, meaning that somebody is inadvertently terminated. But two, the length of the temporary layoff cannot, in most cases, exceed 13 weeks. So what happened is in March and April, when the sky started falling, quite literally, and people were being terminated left, right, and center, those who weren't terminated were being put on temporary layoffs. Now, you might ask, why would employers, non-unionized employers, do this if they didn't have the inherent right to do so? Well, one is because they had no choice. It was, act first and figure out the implications later. But the second was they didn't know any better, right? If you go to the Ministry of Labor website and look at temporary layoffs, it says an employer can put somebody on a temporary layoff for up to 13 weeks. It doesn't say that it could also be a constructive dismissal at common law. But the point is that massive number of people, of employees, were being put on temporary layoffs. Most did not challenge it because the view was at that time, some job is better than no job at all. And thus there was a clock ticking on these temporary layoffs. After 13 weeks, they convert into deemed terminations. Even if the person agrees to the temporary layoff, they don't challenge it. If somebody, under the Employment Standards Act, if somebody is on a temporary layoff for more than 13 weeks, generally, it converts into a deemed termination of employment. So what does the government do about this? On May 29th, a Friday I will never forget, because this regulation dropped at like 4:30 p.m. on a Friday. The government dropped this regulation called infectious disease emergency leave. And what it basically did is it said that if anyone is essentially on a temporary layoff, so they've been laid off or they've had their hours reduced or compensation reduced, but generally if you've been put on a temporary layoff for reasons related to COVID-19, which is incredibly broad, you are actually not on a temporary layoff. You are deemed to be on infectious disease leave. That thing we saw earlier that was meant to provide protections to employees who are, stranded in Peru or otherwise unable to work for reasons related to COVID. So the purpose of this was to remove the threat of a temporary layoff becoming constructive dismissal to protect employers. And also to remove that 13-week time limit on temporary layoffs, again, to protect employers. What this meant is that employees who were effectively temporarily laid off were actually put on a leave of absence for an indeterminate length of time. There's no time limit on deemed infectious disease leave. Taking it further, the regulation said that deemed infectious disease leave is deemed not to be a constructive dismissal. And Ministry of Labor complaints for COVID-related wage claims, like I'm not getting paid because I've been put on this temporary layoff, are barred. So it removes the Ministry of Labor's jurisdiction. And this was said to be retroactive to March 1st. So what this did was it was an attempt to preserve the status quo, basically freeze the non-unionized labor economy, right? Essentially make it so people are who are unable to work for reasons related to COVID don't necessarily lose their jobs, but it had a lot of unintended consequences. It was, in particular, it was a massive expansion of an employer's discretionary power, which also removed Ministry of Labor oversight. Again, all an employer, in order to take advantage of this, an employer just had to have a reason related to COVID-19. Sales are down. Okay, well, we're going to put you on deemed IDL and there's nothing you can do about it. It was an attempt to extinguish protections afforded by the common law, where employees could fight back and say, no, this is a constructive dismissal. And also, too, it was frankly offloading of compensation otherwise payable to the federal government. I mean, normally, if you don't have enough work for somebody and you need to terminate them, an employer has to pay termination pay. But under this regime, what happened was if you didn't have enough work for somebody, or frankly, you didn't like them and you wanted to get them out for under the auspice of COVID-19, you would put them on deemed infectious disease leave, and then that person would just claim EI or CERB for however long. And so really it's offloading that the termination, what should be termination pay, onto the federal government in the form of EI or CERB or whatnot. But there were other unintended consequences. It created a major strain on the implied duties of trust and honesty in the performance of employment contracts. Employment contracts are relational in the sense that you need mutual trust, mutual honesty, and mutual good faith. But again, it gave employers a massive expansion of power, and they could just, we call it putting people on ice, right? Somebody, you got a problem person at the workplace, or, sales are a little bit down, or you don't like somebody or whatnot, you cook up some reason related to COVID-19 and you just put them on ice. You need to terminate somebody, but they have 30 years of service. It's going to be a very expensive termination. You put them on ice for reasons related to COVID, and you hope that they just quit. You just never call them back, and you hope they just quit. On the flip side, there was also an abuse of deemed IDL by employees, misrepresenting circumstances. So, oh, the daycare closed, or, oh, my aunt who normally takes care of my children is unavailable, so I can't work. And there are any number of reasons that an employee could cook up in order to go on infectious disease leave and claim a government paid COVID holiday through EI or CERB or whatnot. So, just as employers were really abusing this, employees were too. I have a number of clients in the PSW sector, in various other similar service-based sectors, and they couldn't get staff because people just they were perfectly happy sitting at home collecting EI. It was a pretty perverse result. So moving on a little bit, here is a question. Well, a statement first. As of today, Ontario has recorded about 527,000 confirmed cases of COVID-19. Is infection from COVID-19 considered a disability within the meaning of the Human Rights Code? And I don't know, maybe I'll just open this up to questions if anyone wants to take a pitch. JP, what do you think? Is COVID-19 a disability under the Human Rights Code?
I would think so, right? I mean, if you're in fear, I mean, like it would be no different than anything else, right? In terms of health concerns that you may have going into the workplace.
That's a completely logical response that you would think is the case, but as in many things, law, it's messy. Short answer, it depends. Believe it or not, it depends on where you get COVID-19 from. And here's why. So the Human Rights Code says that disability means any degree of infirmity that is caused by an illness and so on and so forth. So one would think COVID-19, okay, should qualify as disability. But there is a long line of case law from the Human Rights Tribunal that has said the flu is not a disability because it is commonplace and temporary, and providing disability Human Rights Code disability related protection to a common ailment, which is very transitory, essentially belittles human rights protection. So on one view, COVID-19 is not a disability because it's a comparatively mild ailment that comes and goes. However, the other view is under the Human Rights Code, disability, the definition of disability also means an injury or disability for which benefits were claimed or received under the Workplace Safety and Insurance Act. So in other words, If you collect benefits for something from the WSIB, that is deemed to be a disability under the Human Rights Code. And the WSIB classified COVID-19 as a quote unquote occupational disease. So we have this bizarre situation here where if you contract COVID-19 at work, prima facie, you are protected from discrimination on the basis of disability. But if you don't contract COVID-19 at work, arguably, you might fall into the same category as the flu, right? Something that, it's a really miserable few weeks, and then hopefully you bounce back. So the the Human Rights Tribunal has not figured this one out yet, and there's a variety of reasons for that. One of them is that the current government, prior to the pandemic, cut the HRTO's funding quite substantially and didn't renew a lot of the vice chair's contracts. So the HRTO is running at best at generously half capacity right now. So we don't have answers to a lot of these questions. But I think if I were to bet, I would say that, if you didn't fall into the work-related category of how you got COVID-19, I think it would really be based on a case-by-case basis. If you happen to be one of these people who are lucky enough to have a bit of a sniffle and that's it, and no complications, chances are you don't have a disability within the meaning of the Human Rights Code. But if you're somebody who's unfortunate enough to have long hauler symptoms and lasting complications, I think you would qualify as having a disability under the code. The Human Rights Code is very, how should I put this? The Human Rights Code is very, each case is very fact specific, and there's an individualized approach taken to especially matters of disability accommodation. So I don't think that the tribunal, once they get around to addressing this, will, with a very blanket brush say, yes, COVID-19 is a disability. I think they'll say it depends. And that'll make our jobs as employment lawyers and employment paralegals all the more interesting. But yeah, just some facts here. You might question, how can somebody prove that somebody contracted COVID-19 at work? And the WSIB has been very generous in that regard. 19,000 claims were allowed for COVID-19 by the WSIB, with only a fraction of it, about 10% of them, denied. So some other areas where COVID-19 has really affected employment law is, one of the big ones, how much termination pay do you get if you're let go in the middle of a global pandemic? So as some of you may know, the common law factors used to assess how much termination pay somebody was entitled to, or rather what the reasonable notice period is based on a person's age, the character of their position, the length of service, and the availability of comparable employment. These are called the Bartle factors, after a case called Bartle versus Globe and Mail going back to 1960. And because termination pay is essentially a contract law-based claim, this is forward-looking, if you recall from your contract class on expectation damages. So it's not a question of, JP's an amazing prof, how much should he deserve for doing such a good job after all these years? It's more a matter of, based on his age, character of position, length of service, and the availability of comparable employment, how long is it going to take him to find a new position? So it's all forward-looking. So there was a lot of discussion when the pandemic hit about how this last factor, the availability of comparable employment, would affect notice periods in employment in wrongful dismissal cases. And again, it has somewhat depended. As far as precedent goes, we don't really have any on-point precedents, because I think the last pandemic of this severity was like the Spanish flu. And those cases from that era aren't uncannily. But we have some other cases that we can draw some inspiration from. So one was in 2015, the Superior Court ruled that economic factors such as a downturn in the economy or in a particular industry may justify a longer notice period. There's similar cases from about 2008 after the financial collapse. People who worked in capital market industries, there's one case involving a bond trader, I believe, got a substantially longer notice period on the basis that that sector was particularly hard hit due to the financial crisis. But we got our first word on this issue as to what the notice period should be, whether it's any longer, in a case called Yee and Hudson's Bay Company that came out in, I think it was January of this year. And essentially the court said, it depends on when the termination occurred in relation to the pandemic. So in that case, the plaintiff had actually been terminated in 2019, but as we know, litigation doesn't happen quickly. So it took a while for the case to get to court. And in the intervening time, the pandemic occurred. And so, the court mused that somebody who was terminated in the throes of the pandemic, definitely that could support a longer notice period. But in this case, since the person was terminated well before the pandemic, it had less of an impact. And that's consistent with the previous case law, which hasn't been applied in this precise context, which says that the factors of age, position, length of notice, or length of service and availability of comparable employment, those are all assessed at the time of termination. So it's like when somebody is terminated, a snapshot occurs, and those are the factors that are used to determine the notice period. So there have been cases in the past where somebody's been let go, and then say they get into a devastating car accident and they're unable to work. Well, the fact that they can't look for work after the termination doesn't really extend the notice period, because it's all based on the snapshot as to what happened when the person was terminated. So the answer thus far is it depends. It depends on when they were terminated. And we got a couple more decisions which have helped to illuminate the issue. The latest and greatest word on the subject was from Marizzato and Dell Canada. And essentially the court was very alive to what's been going on. And the court said that not all jobs were affected by the pandemic. In fact, some occupations even benefited. So therefore, actual evidence of pandemic-related hardship is required. A court will not just make assumptions that because it's the apocalypse, everyone is going to be in the same boat in terms of how hard it'll be to find new work. In this case, Marizzato worked in the IT software as a service industry, and that's a pretty hot industry to be in during the pandemic. Employment law, IT professional, those are two that have been that benefited from the pandemic. You look at other types of workers, though, like conference producers, for example. They've struggled greatly because in-person gatherings have been pretty much wiped out. Sports teams coaches, people who work in restaurants, service industries, hotel workers, travel agents are another one. They've had a really, 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 really hard time. So in terms of the impact on termination pay, it depends. Now, I just want to briefly touch on professional responsibilities, and my apologies as I've lifted the rules for professional conduct for lawyers, but I am sure there are parallel provisions in the rules of professional conduct for paralegals. But what I want to highlight here is, this passage from the Supreme Court that said the lawyer's duty of commitment to the client's cause, but the protection of the client's confidence is central to the lawyer's role of administration and justice. And this is sometimes being referred to as the zealous advocacy of representation. You must zealously put your client's case forward and, win no matter what, leave no argument unturned, etc. That being said, the rules also have provisions which say a lawyer or paralegal can't knowingly assist or encourage a client to engage in any dishonesty, fraud, or illegal conduct. In addition, when acting as an advocate, you can't knowingly assist or permit the client to do anything that would be dishonest or dishonorable. So when the pandemic first hit, if you recall, everything happened very, very quickly. Everything shut down, the courts shut down. The way we used to go about things with in-person examinations for discovery, mediations, whatever, all of that was thrown into disarray. There was a period where some firms were refusing to do anything over Zoom or video conference due to alleged security issues. It was a little bit of pandemonium. The court came out, though, the Chief Justice of Ontario came out with a bit of a very pointed practice direction in about April, which essentially told all counsel to, it's business as usual to the best you can and make it work. That being said, the province also issued an emergency regulation which suspended all limitation periods for the duration of the emergency order. So from roughly about March 17th to early September, all limitation periods in Ontario were suspended. And not just limitation periods, but also, the time required for certain steps was frozen. So for example, when you're served with a statement of claim, normally you have 30 days to file a defense if you file a notice of intent to defend. Well, under this emergency regulation, the clock was stopped on those time intervals. And it led to a lot of really bad behavior. So here are some examples. So here's one from my associate that my associate encountered from opposing counsel, who will remain nameless. Examinations for discovery are pretty time intensive. It costs the client a lot of money. A lawyer usually has to do about 2 days of preparation. And when you're charging a few $100s an hour, anywhere from 16 to 24 hours worth of time to do discoveries, it's not insignificant. But yet, here we go in November, one day before discoveries, we get this email saying our client's representative advises us that he feels sick. He took his temperature at work and he has a fever. He won't attend tomorrow's discovery. Perhaps we can reschedule to avoid a cancellation fee. And the best part was our client had a mole inside the company who said that was total BS. And the guy, the owner, was actually at work that day and never went home. So that was a pretty shady move. We ended up being able to reschedule in short order, and the client wasn't out much money. But it's just one example. Here's another one from when limitation periods were suspended. It's a letter from opposing counsel after we sued them, who said, we're counsel for so-and-so. The defendant continues to grapple with the effect COVID-19 has had on its operations. Accordingly, and pursuant to the emergency regulation, the defendant will not be serving and filing a statement of defense for the duration of the emergency. If you have any concerns, please feel free to get in touch. Well, hell's no, especially since with this particular employer, we actually served them with the claim in person at their place of business, which was still open. And yet they're saying that they're grappling with the pandemic and they can't participate in the litigation. Making matters worse too, this was one where my client had been terminated for cause, so capital punishment of employment law. So one would think that if the employer felt that it was in a position to terminate for cause, it would have its ducks in a row and therefore be able to participate in the litigation. So what happened with this one was I said hell's no, and I filed a request for a chambers appointment, which is they're about very brief 15-minute informal appointments with a judge who basically says, what's going on, how can I help? And within the request, I'd given a brief description of what's going on here. our affidavit of service from a process server says they serve the claim on a fully functional workplace that's open for business. And now they're saying they're not going to participate in the litigation. So Justice Myers wrote a very, very stern email back to myself and opposing counsel, more so directed at opposing counsel, saying, get your stuff together, figure it out. If you have to appear in front of me, I remind you that I can award costs during chambers appointments. Sure enough, opposing counsel said, okay, we'll file a defense. Let's get this in order. But again, an attempt at bad behavior without any foundation. And then lastly, this one was particularly egregious. I don't expect you to read it all, but essentially what happened was we had come to a settlement in a long fought piece of litigation. And out of the blue, the employer tried to resile from the deal. And the employer said, basically, oh, times are tough because of COVID and we can't actually pay the amounts that we said that we could pay. And in particular, we need a year in order to pay what we can pay. And here's an affidavit to that effect. And he's making this very bold claim after, instructing his counsel to accept a settlement that he tried to get out of. And look at this paragraph. While I have not yet prepared or received financial statements for the applicants, I can attest that the applicants have experienced a significant decrease in revenue. Well, if you don't have financial statements, how the heck can you put in evidence that they've experienced a decrease in revenue, a significant decrease in revenue? It's absolutely crazy. Anyways, this was another one that was like, hell's no. And I can't believe that the employer's lawyer played along with this to bring this kind of proceeding to get out of a settlement without any hard evidence whatsoever. But anyways, we were like, all right, you want to bring an application to get out of the deal? Fine, let's bring it in front of the court. And sure enough, 2 hours before this guy was about to be cross-examined on this affidavit, in which they knew we were going to ask for undertakings on all sorts of financial data, which would essentially prove that he swore a false affidavit. The other side just capitulated and said, okay, fine, we'll do the deal. Certified check is on its way. So again, very, 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 very bad behavior that has propagated during the pandemic. So those are just the highlights, because I know that this is an interactive session and people may have questions to ask. So I will turn it back over to you, JP.
Perfect. So I see a few questions here already, and I think we'll probably get into a few more. So we were talking about COVID, and we were debating and grappling essentially with disability, not a disability, but in terms of what happens if you either have COVID or feel that there was a risk of it. I mean, maybe not so much at this stage in the pandemic, but again, who knows with the workplaces. If you say, look, I'm not coming in, I have to be in, if someone's insisting on you being in person, and you say, look, I'm not coming in, and then they fire you in response to your refusal to enter the workplace, what happens? Or what depends, I guess, is when we first put it out of your mouth. But what can you maybe look at it on both sides there? What could happen in one regard? I mean, I suppose it depends on the workplace itself, but let's say if it's not an essential workplace that was open at the time.
So what that turns on is whether the fear, the health and safety related risk is grounded in objective reality or subjective concern. So step back a moment. The Occupational Health and Safety Act says that workers are allowed to refuse unsafe work. Nobody can be forced to work in, construction setting where there's live electric wires everywhere or what have you. And by the same token, a workplace, if there's no physical distancing, no PPE, anything like that, that can be considered a hazard. So what we saw a lot during the early days of the pandemic was people refusing to go to work because they didn't want to take the TTC. and they claimed, it's not safe for me to take the TTC just because. That's a subjective fear. So generally, when there's a work refusal, the employee puts their foot down and says, nope, I am not doing this job. It is unsafe. And then the Ministry of Labor has to come in, and an inspector assesses the situation and then either says yay or nay to that. So when a lot of people were refusing to come to work, and this is leaving aside stay-at-home orders and all that kind of stuff, but assuming that a person was required to go to work, people who refused to do so just based on subjective concerns about the public transit, I mean, that's not good enough, frankly. We had a case involving an HVAC technician who was dispatched to do a job at a long-term care facility. And he just said, nope, not doing it. It's not safe. It's a long-term care facility, not doing it. And, we had to deliver some bad news to him in the sense that that's not enough, right? I mean, the government put out guidelines about what kind of PPE is required based on certain risks of exposure and so forth. And it's not enough to just say long-term care facility not doing it. There has to be more, like the employer's not giving you any PPE. On top of that, maybe the person is immunocompromised, right? So they're at greater risk of greater complication. There has to be something more. It has to be objectively based. It can't just be subjective fears. So there was a lot of that early on. It's largely dwindled down a fair bit, which is good. But yeah, it was pretty hairy for the first few months.
Yeah, I think because we're at kind of a different stage here to what we were just talking about. What about in terms of, hey, I've gotten used to, we can certainly say that we can deliver things effectively to some degree. I mean, we've certainly just discussed about this before starting here today about things remotely. Can I now say, well, look, I have all these childcare issues that I've been able to work remotely now. Me coming back into the office, maybe not necessarily a health concern, but just a matter of, is this grounds under the Human Rights Code to say that I'm not being provided enough accommodations, given that we've excelled to some degrees in some fields with working from home or working anywhere?
Welcome to like at least half my day every day for the past couple of weeks. Employers are having a lot of trouble getting people. There's still a stay-at-home order in effect, but employers are facing massive resistance from employees who want to continue working from home. They don't have to take the go or the TTC. They're saving money. They're not buying lunches out every day. They're very comfortable at home, and they feel like, well, things have gone pretty well so far. Why can't I just keep working from home? And so they're inventing or exaggerating certain reasons. Some of them are valid, some of them are not. And it's going to be very tricky. You've got to step back and look at first principles, right? So somebody who says, I want to work at home. Well, first of all, are they protected by the Human Rights Code? So do they have a disability within the meaning of the Human Rights Code? Or do they have a legitimate childcare issue within the meaning of the Human Rights Code? If so, then you go to the accommodation analysis. Working from home is one form of accommodation, but the duty to accommodate does not give people carte blanche right to their preferred form of accommodation. Okay, the duty to accommodate is a multi-party responsibility. Everyone's involved. Some level of compromise is required. So, some of this, if somebody claims to have a medical condition, employers are not allowed to know it can't be force somebody to disclose what their exact diagnosis is, but they can get information from a doctor about the nature of the condition. So, if somebody has asthma, for example, not to belittle the condition, but potentially a greater risk of complications from COVID-19. If the doctor's like, due to medical condition, patients should work from home until further notice. But if an employer writes a letter to the doctor saying, okay, well, what if we pay for the person's parking at the office building, and we can guarantee that in their department, everyone is being vaccinated. And on top of that, people are wearing face shields and face masks, and they're not interacting with members of the public. Then what? And doctors, I think, I mean, doctors sometimes, to their credit, are advocates for their patients, but they lose their objectivity, right? And in that case, if the doctor says, nope, that won't suffice, well, then the employer can ask the employee to attend an independent medical examination and get a different take. And it can become, things can, really start to heat up from there. So yeah, the short answer is, for these people who have been working from home, how do employers say they can't accommodate it when it's been working fine for the last year? The short answer is that employees don't get their preferred form of accommodation.
And I guess practically speaking, if they're all things considered the same, I mean, rather than go down that sort of rabbit hole, I mean, if a company is in a position to keep their workers or keep them there, even that might be something that they would look at practically, like, oh, you know what, maybe we could win this under the law, but why not try to accommodate if it kind of helps keep morale going, I guess, in the workplace too.
Well, I mean, practically speaking, often what happens is these discussions and requests for medical information and whatnot tend to get a bit tense. Often during those discussions, there's a segue to somebody saying, "Look, do you just want a severance package?" And half the time that's the way it goes, right? And it just kind of resolves that way. But it is going to be a major area of contention, I think, going into the fall, and I'll be interested to see what comes out in terms of case law, because yeah, I mean, there's legitimate needs to people can work from home, but are they doing everything they did before, right? Somebody somewhere is picking up the slack, somewhere there's an inconvenience, somewhere there's inefficiencies, and at the end of the day, employers are businesses. So I'm sensitive to employees, but on the other hand, the duty to accommodate is intended to give people to ensure equity in employment. It's not meant to give people preferential or superior rights. And I know that sounds harsh, but sometimes people lose sight of that.
And on the flip to that is that, if they want you back and vaccinated and all of that, so they can say, look, we've looked at all the safety risks, and you have one of those either anti-vax people, or they just lazy or don't want to get, they got some anxiety about it, or, depending on the Pfizer or AstraZeneca or something like that. I mean, for whatever reason, they're just not ready to do the vaccines. Is that something that can be done in reverse, to say, well, if you don't get vaccinated, then we just won't call you in to work?
Yeah, no, very interesting question. So a few things. What I have started encouraging clients to do is, when making offers of employment to people, making it a written term of the offer that the person will undertake to become vaccinated for COVID-19 and any variants at the earliest opportunity. And that way, it's it's upfront. If you want the job, this is what we're going to require. Now, of course, there can be the human rights exceptions to that. If there's a bona fide religious belief or a bona fide medical condition where objectively it's not recommended, or at least the jury's still out as to whether vaccination is safe, then an employer has to be mindful of that. But for everyone else, I think it's an important tool in an employer's toolkit. In terms of existing employees, there is no human rights protection to having a belief that Bill Gates is trying to put a microchip in your head, or that COVID-19 will turn you into a 5G antenna or something. Like it's all like that. There's no human rights protection for that whatsoever. Now, that being said, it's very easy. People will just ask a very loaded question. Well, can my employer make me do it? Can it be mandatory? And you have to unpack that. Does an employer have just cause for dismissal if somebody refuses to get vaccinated? No, 99.9% of the time. It's not just cause for dismissal. But that doesn't mean that an employee is not immune from consequence. So, for example, Here's one. If you're a cleaner in a residential condo building, which means you're often in elevators, close quarters with people, with residents, and you refuse to get vaccinated. Well, I think it's completely legitimate for the employer to say, all right, well, we not only have to have a duty to keep our staff and residents safe from you, but also we have an obligation to make sure that your workplace is safe and to keep you safe from everyone else. So as a result, you're going to be working the graveyard shift, 11 p.m. to 7 a.m. and I think that is completely reasonable. As well too, if there's no human rights related grounds at play, and somebody just thinks that the vaccine is going to put a microchip in their head, an employer can just terminate without cause, right? Or they can give them working notice. They can say, sorry, it's not going to work out. Your job will end in 6 months. So an employer has tools, right? The views that vaccination is a personal choice and an employer can't make you do it. Well, it's true. They can't actually force you to put the needle in your arm, but they can create disincentives. And frankly, this is nothing new. I mean, our public school system, you can't send a kid there unless they've been vaccinated for measles and mumps and so forth. So I don't think this is controversial.
No, we were talking about earlier, I think you were just talking about it just there about the Bardell factors in terms of securing other employment. But does that also work in the sense that from an employer's perspective, well, we're facing these unprecedented times, so
I know where you're going with this. Nope. No, employment law is not the employer side of employment law is not a mirror image. No, no. The Court of Appeal decided a number of years ago that an employer's financial circumstance is irrelevant to the question of reasonable notice. An employer's ability to pay is legally irrelevant, right? I mean, if they go bankrupt, you can't collect. But again, the question of what is reasonable notice, it's a snapshot at the time of termination based on the individual's characteristics. Now, with that being said, it does not play into it doesn't go to the question of what is reasonable notice, but an employer can have a defense to a wrongful dismissal claim based on something called frustration of contract. And that occurs when an unexpected intervening event strikes such that it makes the employment relationship impossible to perform. So, what I would tell my students at Osgood, the example I would use is, say you're a truck driver and you get busted for a DUI and you lose your license. Well, it's impossible for you to do your job now, right? So that's frustration in contract. So it was quite interesting. During the pandemic, some employer counsel for travel agencies and whatnot tried to take it on to say, well, travel agency industry is being decimated. Flights are grounded, airports are closed. Clearly, it's frustration in contract. But it's a high bar. It's impossibility, right? And so then you got to look at questions like, well, does the employer have business interruption insurance? Because if so, we can't say that it was unforeseen because clearly they foresee it. That's why they got business interruption insurance, right? So there was a lot of talk early on about whether an employer could have a defense using frustration in contracts, and I struggle to think of how that could apply, especially when you've got the deemed IDL provision and these other things. Because really, nobody forced the employer to terminate somebody, right? But yeah, sorry, I didn't mean to jump in, but I knew where you're going with that question.
Yeah, I think that's exactly where I was going, because I think now you were talking about, I think someone was asking you about ethical considerations. We had that whole thing about some of those examples from opposing counsel. Now, have you sort of looked at situations? I mean, I know you do both employer and employee side, but I mean, part of the thing is there, the mitigation of loss. And if you're going to say, well, hey, I'm just going to sit and collect CERB forever or for as long as possible, how do you kind of look at an ethical situation like that in terms of your duties there? Of, again, I mean, you had the whole slide there. What it emphasizes, I mean, and it's a little different, but pretty much the same thing for paralegals as well. But how do you encourage, I guess, someone to continue to look for work and mitigate that loss when the government is basically saying, hey, just if you've been affected by COVID-19, here's $900 bi-weekly. And if I can get a job that's paying me $1,000, why would I work for, after taxes, it's like peanuts, right? But
yeah.
How do you manage that?
Well, so what you say is you have, like, this is how you prove your case, right? So literally, in order for an employee to prove their damages in a wrongful dismissal, they need to show evidence that they looked for work. Okay, there was a case from the divisional court a number of years ago where the plaintiff's lawyer was sloppy, I guess, and took the thing to trial, and his client, or her client, I forget who it was, the employee didn't have any proof that they ever looked for work. And the divisional court overturned the small claims decision because the divisional court said that the person has no proof of loss, right? It's a reciprocal obligation. An employer has an obligation to give reasonable notice or pay in lieu, but only insofar as the employee is taking reasonable steps to mitigate their losses. So they're two sides of the same coin. So if you have a client that says, yeah, give me some termination pay, bro, and but really I'm not going to look for a job, I'm just going to sit here and watch Netflix, then what you say is, okay, well, I can't get you termination pay if that's what you're going to do. You need to look for a job, and you need to, just keep a little spreadsheet of what you're doing. And to the extent that you're not actually looking for a job and putting together false evidence, well, I can't be your lawyer then. And if this person has half a brain, they'll put two and two together and realize that if they want you to be able to get them anything out of this, they have a part to play as well.
I guess on the employer side there, or whoever kind of wants to benefit from some of those suspended periods there, I mean, what is that? How do you kind of walk that fine line of, well, maybe it's advantageous, I think, in some of those situations, like, let's wait and see how things play out. But at the same time, I mean, your ethical obligations, I mean, what advice maybe for students here, we're looking at, how do we find that balance of duty to, as licensees at the same time, but then our duty to clients in terms of, we don't want to get disciplined by the law society, but at the same time, we don't want to do, prejudicial work for our client because we're not kind of taking advantage of, I guess if that's the phrase there, right? Taking advantage of a situation that kind of benefits our client.
Yeah, the defendant's job is always to, or not job, I should say, the defendant's number one play in their playbook is always to delay. But you as counsel need to at least give the appearance that you're not intentionally delaying. So what does that mean? It might mean reaching out to the other side and saying, client is a mess due to COVID. Can we have an extra 2 weeks to file our defense, right? They want to schedule something and you need instructions and it takes a while to get instructions from your client. I mean, let me put it this way. A whole bunch of micro delays can add up and be far less suspicious than, one giant unexplained delay, right? So it's not that I'm telling anyone to do anything unethical, but at the same time, you can reconcile that tension between advantages for your client and still being ethical by being on it. And at the same time, if you're busy and you can't respond to something right away, or your client's busy and they're not getting back to you, at least keep opposing counsel in the loop, right? Just want to give you a heads up, put your proposal to my client. I'm trying to set up a call with them. I know they're really busy. Hope to have an answer by the end of next week. And again, you are communicating with the other side, but at the same time, like, all these little micro delays will add up.
Yeah, you're not just dropping like a bombshell a day before the hearing, right? So
unbelievable.
Now, right, completely unrelated to what we were just talking about there. I think I know few weeks ago we were doing tribunals, and I think one of your articles came up about
Oh, okay.
genetic characteristics there, and I think it's like the 6 Minute Lawyer. I think you had done a speech, and there was like a very vigorous debate on kind of what people can do in terms of, it's obviously unique to federal legislation rather not in the Human Rights Code. So I think that's kind of where we were looking at the difference between Ontario and Canada. And maybe you can touch on kind of what is potentially where that comes up, or where maybe you've had cases where it's come up where someone's saying, look, I'm being discriminated because of these markers that may come up, or can they order me to do one of those like 23andMe sort of things? How does that come up into practice?
Yeah, so so a little bit of an update since that paper. So the feds passed the Genetic Non-Discrimination Act in 2017. It was challenged at the Supreme Court by insurance lobby groups. Well, to back up, what did the Federal Genetic Discrimination Act do? It amended the Canada Labor Code, so basically the federal version of the Employment Standards Act, to prevent federally regulated employers from requiring genetic tests or requiring disclosure of genetic tests. So BMO, RBC, Bell, Canada Post, whatever, those employers can't make you get a genetic test or disclose the results. And it also amended the Canadian Human Rights Act, so again, the federal version of the Human Rights Code, to include genetic discrimination, genetic characteristics as a protected ground of discrimination. So insurance lobby groups challenged it at the Supreme Court, saying it was ultra vires, because obviously insurance companies love the idea of having genetic information, because then they can say you have some weird mutation somewhere in your DNA. So, now your insurance premiums have tripled. So they challenged it as being outside of federal law because, reminder, we have a division of powers in our Constitution, and the provinces are responsible for most things, but then the feds have exclusive power over certain things like criminal law, banking, telecommunications, so on and so forth. So the Supreme Court ultimately decided that it was not ultra vires. The Federal Non-Discrimination Act, Genetic Non-Discrimination Act, was legitimately within the ambit of federal power to legislate in the area of criminal law. And you might say, well, why criminal law? This has nothing to do with what we understand criminal law to be. But the Supreme Court ruled that historically, legislation that protects autonomy, privacy, equality, safety, public health, these are all within the ambit of criminal law. And that's ultimately what the pith and substance of the federal Genetic Non-Discrimination Act intended to address. So it's law, it's on the books, and it withstood that challenge. Now, provincially, there was an attempt to amend the Ontario Human Rights Code to add genetic discrimination to the Ontario Human Rights Code, but then new government came in. Conservatives aren't really in the business of giving people expansive rights, and so the bill just kind of died. And didn't go anywhere. So in terms of how this can come up, so federally it's very clear. If an employer wants you to take a genetic test, they can't. You can flat out refuse, or if you have taken one, you can flat out refuse as well. I can't really think of an instance, though, where an employer would necessarily want you to do that. I mean, perhaps on some level in terms of assessing, group benefit costs, if you're like a high risk person who's going to increase their premiums. But at the same time, two things. One, federally regulated employers are the biggest employers in Canada. Again, it's the banks, it's Bell Canada, it's TELUS, it's Air Canada, Canada Post, like massive employers. And the whole nature of group benefit plans is that the risk is shared equally. The risk is spread out. So I would be kind of surprised if a federal employer would even turn its mind to that, because the whole nature of group benefit plans is to spread out the risk. So if you've got somebody who, puts like $10,000 a month through on like the drug plan, I mean, it ends up being like a drop in a bucket or a drop in a sea, right? At the that being said, at the provincial level, it's interesting. We don't really have robust privacy protections in Ontario as far as legislation goes. There is a tort, the invasion of privacy tort, otherwise known as intrusion upon seclusion. Again, as well too, there's always that sort of lurking risk of constructive dismissal. And basically what it would probably come down to is that there's an implied term for employers to give legitimate, reasonable directions. And if an employer, wanted you to take a genetic test for, I don't know what possible reason, I don't know if that would be kosher in terms of it being a reasonable, legitimate directive. And if they insisted on it, well, then it's a breach of that term and an employee can treat it as constructive dismissal. Alternatively, I think it's fair to say there's an implied term that employers will not collect more information that's reasonably necessary in order to protect or administer the employment relationship. So for example, you don't have employers asking for your family history tree. You don't have employers asking you for, I don't know what your LSAT score was. Like employers don't, there's no legitimate need for that, right? So I think if an employer asked for a genetic genetic test, again, it could be constructive dismissal on the basis of a breach of an implied term about data collection. I don't know where it could come up. It's maybe in an instance where, like you're a driver, and the employer pays a lot in terms of insurance, freight insurance. If you drive cargo trucks or whatnot, or you're a school bus driver or something, I don't know. But even so, actually, I don't know, because that goes to, how good you are at driving, and that has nothing to do with genetics. So I don't know. I struggle a little bit. It's an interesting issue where it's very easy to see how it could be extremely nefarious, but at the same time, unless you've just got a crazy employer, I kind of struggle to see how it could come up in the normal course. Now, frankly, an interesting one, if there was any an interesting one could be the emerging view that some people are more susceptible to COVID than others based on genetic characteristics. And so whether that becomes a safety thing, right? I'm not taking the TTC because I have that a certain cellular mutation, which makes me at the highest extreme risk of mortality from COVID. That's an objective fact. That's not a subjective fact. How does that play into work refusals? So, but that being said, in this job, I'll say I'll never see that. It's entirely possible I will, but I think it would be quite unexpected for somebody to make that argument.
Certainly, always, we have in law a lot of these hypotheticals that, we look at it, and one day maybe there'll be something that will sort of put the test into reality there.
So it's always fresh and interesting when you're an employment lawyer, just when you've seen it all.
Perfect. So Ryan, thanks as always for joining us here. It's always a pleasure. Always lots of information and from the material there, and I think it's very interesting, as you said, and lots of changes. Mm-hmm. So I know I have a lot of students, especially right after we finish employment law, and I think especially with the small claims limits going up from 25,000 to 35,000. So it does certainly open up that aspect a little bit more for paralegals, as well as obviously all the tribunals and human rights and everything that have all these other issues that they can get into. So any advice now? I mean, certainly I think you have a very interesting journey from Heenan, and I actually had my good buddy John Tong on. We're talking about sort of how, who would have thought that, speaking of employment, a law firm of that size can just disappear overnight almost.
Read the book. Read Norm's book.
I had Norman on as well, which is also interesting. But in terms of that transition there, starting your own practice and not looking back, and solely in employment law, right? I mean, any advice you have, any final words for people looking to get into this field, and how to sort of succeed in that practice?
Yeah, for sure. So I think a little known thing about working in this space is that it's, private practice is only one slice of it. So to all of you enrolled in the paralegal program, I would encourage you actually to look at melding it with some sort of post-grad certificate in HR or something like that, because there are a lot of quasi-legal employment law related profession or jobs available at big companies. So for example, the banks, they're frontline negotiators for dealing with employee issues, both wrongful dismissals, but also disability accommodation, whatever. The job is called, typically called employee relations consultant. Some of them are former lawyers, some of them are former lawyers, some of them are have law degrees, some of them have paralegal training, some of them are purely HR. But I think that there is a very large need for HR people to have some type of legal training. And I think that melding a paralegal background with HR training is a very, very potent recipe for job prospects, for sure. So again, there's the sort of private practice aspect to being a paralegal. But I think in-house positions are overlooked. And I don't mean in-house in the sense of you're in-house counsel. I mean in-house in the sense of you're an employee relations consultant, you're a labor relations person, right? I think that's very, very overlooked. Now, you might say, well, could just paralegal training do it? HR is, in my experience, a profession that wants to validate itself. So in other words, in order to be invited into the, and I use the HR term very, very broadly in terms of everything, whether it's employee relations, union relations, health and safety, pension benefits, whatever, they want to see evidence of interest. Demonstrated interest in the field. So whether it's some post-grad HR certificate, or you have started, taking courses from the Human Resources Professional Association, ad hoc courses, or just something on a resume to really show a demonstrated interest in the area. But yeah, what I see in a lot of the HR field are people who grew up with HR and have no legal training, and as a result are not the strongest when it comes to certain concepts like reading legislation or understanding the common law. Or you have people who, to be frank, are somewhat overqualified, right? They practiced on Bay Street for 8 years and paid off their mortgage, and now they're looking for an easier way of life. But at the same time, probably command a very large salary. So I think there is definitely a missing link, right? And I think, combining an excellent paralegal education with some HR training can lead to a very prosperous career.
Perfect. So thanks, and thanks everyone for all the questions there. I see one that just popped in about toxic environment equal constructive dismissal. I think Ryan probably would say it depends.
Well, toxicity, it has to be objectively toxic. Yeah, not the employee's subjective views about the workplace are not determinative.
So there you have it. So thanks again, Ryan, and thanks again, everyone, for all the questions and joining us here today. Wish you all the best, and certainly in all these uncertain times, the law is also changing. I mean, maybe you can log in right now and there'll be a new regulation passed that changes everything again. I
only got 7 emails in the last hour, so I'm thinking that it didn't.
Take care, Ryan. Thanks again. And
right, thanks, JP. Thanks for having me all. Ciao.
Thanks so much, Ryan. And thanks, JP. Have a great day.